Thanks everybody for being here. My name is Derrick Hogan. As Taylor said, I'm a managing partner here at Tully Rinckey. I've been practicing for about 13, 14 years at this point. I've focused my practice on criminal law and also some federal labor employment law. But my initial intro, I guess, to the legal field was in criminal defense. So I've been handling types of cases like this for a while. And thank you for everybody for coming today, and hopefully I can spread some knowledge and get you guys a little bit educated on DWIs and the processes. So initially, I would say let's begin with an initial police observation, a stop, if you will. And if you want to go to the next slide. Great. So, everybody knows what a DWI is. It's driving while intoxicated, maybe by alcohol. There's also DWAI, driving while ability impaired. Sometimes that could be by drugs, whether it be, some type of stimulant. But the main point to understand with a DWI is there has to be an initial police observation. And in that initial police observation, they must observe, I think it goes without saying, and it might sound silly, but they actually have to observe someone operating a vehicle. If someone is parked in a parking lot with their keys in their pocket, their car's off, and the engine might not be running and it's cool to the touch, I would argue that that's not an actual vehicle operation. So while it might seem silly, one of the things you always have to consider in these types of cases is, was the person operating a vehicle? But assuming someone is operating a vehicle, police have to notice a valid vehicle and traffic stop. And that could be any violation under the New York State vehicle and traffic law. What's some common examples? Maybe speeding, talking on a cell phone, failure to use your signal. Those are all types of VTL violations, vehicle and traffic law violations, that officers can use when observing a vehicle, when observing an operator, and to determine whether or not they have probable cause to pull that person over. And as you'll see in the slide, regardless of how inconsequential that violation may be in the eyes of the operator, you might say, well, I didn't put my signal on, I put my signal on right before I turned, but the rule is it has to be within 100 feet of the intersection. Or I didn't cross the double yellow line, only slightly. So in the eyes of the officer, as long as that person commits a vehicle and traffic violation, they have probable cause to initiate a traffic stop. And you'll see there on the slide that an unregistered vehicle, that if an officer is checking DMV records to determine whether a vehicle is registered, despite observing no VTL violation prior to doing so, they do have, that does not constitute an impermissible search. So next slide, please. Okay, one of the things people might ask about is a fog line. As an initial matter, if you're not aware, the fog line is the usually solid white line on the right side of the road, which separates the actual we'll call it the driving lane, from the shoulder and everything to the side of it. And crossing the fog line doesn't necessarily appear to be a valid basis to stop a vehicle, but only trial courts have dared to say so, meaning if that is the officer's justification for pulling you over, it might not be something that can be thrown out so easily, and it might be something where you're arguing at trial as to whether crossing the fog line is a valid reason to pull over a vehicle. Now, before we go into some of these cases here, you also have to understand you could be crossing a fog line, but you could also be doing other things such as speeding, failure to signal when you change a lane, recklessly driving. Any other combination of VTL violations will constitute probable cause to pull someone over. But going back to the fog line issue, we see a couple cases where it says, briefly driving on the fog line did not create a reasonable suspicion to justify a stop. Intermittent contact with a fog line did not provide reasonable suspicion. Crossing a fog line a single time for approximately 3 seconds did not rise to reasonable suspicion. And then looking at the last context, crossing the fog line does not constitute a VTL violation that provides the basis for the stop. So, you know, I could still see an officer stating that he or she pulled you over because you crossed the fog line, but based on the case law, it's going to have, you know, it's going to have, the officer's going to have to justify why they pulled you over for that reason. And obviously, I think if it's like the one case that says it's a 3 second, that's one thing. But if you're going in and out of, let's call the right lane, and you're crossing over the fog line multiple times, I think you're going to have a harder time justifying that the stop was not reasonable. Next slide, please. Okay, roadblocks. Everybody is familiar with roadblocks. Usually they're set up, I know in New York, by state police. A lot of times around holidays, say 4th of July, Memorial Day, things of that nature. Basically, when law enforcement thinks that there's going to be an extra amount of people outside drinking, consuming alcohol, maybe driving, something like Halloween, things of that nature. And roadblocks, they are constitutionally permissible. And the thing about roadblocks is they have to have a very defined structure. And you see there, it says that because the roadblock constitutes a warrantless and suspicionless seizure of a citizen, it may only be operated under very limited circumstances and for a very specifically defined purpose. And that purpose must be known by all officers involved. Roadblocks may not be constituted for general crime deterrence. So right there, you can't just set up a roadblock because you want to make sure crime is not being committed in your city, town, village. There has to be a defined purpose. And they can't just, you know, set these up on a whim. And I think those are a couple things to keep in mind, is that you have to have a plan and you have to stick to it. So you see the example there. You pull over every 5th car. If the 4th car is pulled over on a hunch, that is unreasonable seizure despite the existence of the roadblock. You know, you also see roadblocks to, well, let me check your inspection. Let me check your registration. But if that is the defined purpose for the roadblock, let's just say it's for a registration or inspection check, then I think an officer is going to have to go above and beyond to say they do think someone's driving under the suspicion, the consumption of alcohol. They're going to have to really prove their case as to why they continued down the road of someone driving under the influence, if the road check was just a check to see if there's a valid registration or valid, say, inspection sticker. And as you see there, roadblocks to catch drunk drivers are constitutionally permissible. Next slide, please. So, kind of piggybacking on what we just talked about, that the roadblock requires a legitimate primary purpose. If a primary purpose is to check the license or registration, then the roadblock will be constitutionally permissible. However, if the primary purpose is general crime deterrence, then the seizure will not pass muster. And unlike traffic stops, a legitimate secondary purpose will not save the roadblock if it does not have a legitimate primary purpose. Another thing you have to see with roadblocks is all the officers and agents, they must be educated on the primary purpose of the roadblock and the methodology in executing it. And I think that's something I would hope that our law enforcement go through. You know, I doubt it's just something where they say set up on this road and start checking every 5th vehicle. My impression would be that law enforcement, this would be a coordinated effort. They'd have meetings prior to, okay, on this date or this weekend, we're going to set up roadblocks. Here's the test that we're going to go through. Here's the reason why we're doing it. And I think sometimes you see, you know, sometimes the state police, they put out press releases to, you know, inform people ahead. Hey, we're going to be checking for drunk driving here on 4th of July weekend. Or, you know, sometimes when you're traveling on our interstate, you know, maybe the thruway or another interstate, you'll see one of the signs, the neon signs lighting up and basically saying, you know, warning drivers that roadblocks are coming up, road checks are coming up, be safe, things of that nature. So you have to have an educated team of law enforcement, and certainly, as it states there, a lack of knowledge can invalidate the entire roadblock, which would lead to evidence suppression. And the last point of this slide here is you have to have strict compliance with the methodology. The variance from the preordained methodology will inject arbitrariness and bias into the roadblock, thereby invalidating the seizure. And then I think you see in the parentheses, unless the officer has reasonable suspicion that can be articulated on some other basis. So here's how I look at it. You have a roadblock set up, whether it's to catch people driving under the influence, maybe it's to check inspections, check registrations, and that's got to be the strict method of compliance. And an example could be someone goes through the roadblock and then they have a firearm sitting on their front seat. So I think that goes into the parentheses at the end there, and there's reasonable suspicions that can be articulated. So if you're going through a roadblock to check alcohol consumption or to check an inspection, and you have a firearm sitting on that front seat, I would say an officer has a reasonable suspicion that some other crime is being committed, obviously unless you have a permit to possess that firearm, and I don't think that information or that evidence would be suppressed should an individual be arrested for, like I said, criminal possession of a weapon, or maybe you have just happen to have a bunch of drugs sitting on your front seat. Although that was not the purpose of the roadblock, if something is in plain view, I think an officer is going to have an articulable reason to justify the seizure of that weapon, contraband, whatever it may be. Next slide, please. There are some specialized circumstances for roadblocks. United States Customs and Border Protection, under the Homeland Security, does have the authority to set up immigration checkpoints to prevent aliens and contraband from crossing the border. And their authority extends 100 miles from the border. I think just with this point of this slide is that if you have a CBP checkpoint specifically regarding illegal aliens or contraband, just as it says there, once it's established that the vehicle's occupants are legally in the United States and there's no reasonable suspicion they're carrying contraband, the basis for the checkpoint is concluded. So there's no other, they can't, I guess, pry for more information or try to find more evidence of some type of legal activity. Is once that strict compliance is established and they've satisfied what they're doing the road check for, then essentially they have to move on. Next slide, please. Okay, now we're going to kind of get into once the vehicle has been stopped. If anybody's been in this situation or maybe seen it on TV or just in their normal practice, an officer pulls you over, you pull over to the side of the road, hopefully on the right and in a safe area. I know it's not always easy to pull over in the most safest spot, and the officer is going to observe you. They're going to look at your physical state. They're going to look at everything from your hair, your clothing, your eyes, your cheeks. Do they detect any odor of alcohol beverage? The manner of your speech. Is it slurred? Is it heavy? Are you stumbling? Your moves, and your ability to follow instructions such as providing a driver's license or registration. And that's going to provide them the probable cause to move on to the field sobriety test. Now, something to keep in mind, officers do have a right to pull you over. They do have a right to ask for this information, and they do have a right to make observations. And I think a good point for any driver is that you might not feel you're impaired, you might not feel your eyes are bloodshot, but I think it's important to comply with the officer's direction, as long as it's not overly burdensome or just plain wrong. I think that the more you necessarily comply with the directions, the better chance you're going to have of them maybe not giving you a hard time. Now, obviously, if someone is extremely intoxicated, they're emanating alcohol from their pores, they're being skittish, they're not necessarily complying, that's going to give an officer more reason to try to move on to the field sobriety test. So something to keep in mind, whether it's in your own personal life or with your clients, if a client is refusing to comply with orders, as much as that client might disagree with those orders, the non-compliance is going to give law enforcement a reason to move on to the field sobriety test. So when an officer is under the impression that someone has been drinking alcohol or is impaired by a drug, they can ask, have you been drinking? And that does not necessarily require a Miranda warning, as it's a non-custodial interrogation. And the driver may invoke silence under the Fifth Amendment or counsel under the Sixth Amendment. So, and moving forward, when we talk about the field sobriety test, the driver may refuse to even take this field sobriety test without a penalty. However, sometimes a client will run into an issue with that because there's something called a consciousness of guilt instruction. And specifically, if you go to a jury trial in connection with, a driving while intoxicated charge or a driving while ability impaired by drugs charge, if you refuse to take some of these field sobriety tests, going back, if the officer has established probable cause to, one, pull you over, and then two, to conduct the field sobriety test, and then you then refuse the field sobriety test, there will be a consciousness of guilt. And that jury instruction will be basically that you can imply that by the individual refusing those tests, there is a consciousness of guilt. And that doesn't mean necessarily that you will be found guilty, but I think all of us who are attorneys know that if you have a consciousness of guilt jury instruction and your client has remained silent on that topic, it's certainly more favorable to a prosecutor than a defense. So once those things are established, the officer believes he or she has probable cause to ask the driver to perform field sobriety test. They're going to perform tests in these orders: the horizontal gaze nystagmus, the walk and turn, and the one-legged stand. And these next couple slides coming up, we'll discuss each one of those tests. So next slide, please. Okay, so for each of these tests, I'll probably bore you with the instructions, but I think it's important to go through them. And these are some standard instructions that an officer would give when performing these field sobriety tests. So the first one, horizontal gaze nystagmus, usually involves, shining some type of light into an individual's eyes. Usually it's a pen. The most common one I've seen is a pen with maybe a little light on the end, or an officer has a pen, has his or her flashlight, and basically is flashing a light into the driver's eye and to see how their eyes move. And kind of the instructions here, they're going to check your eyes. They're going to ask you to keep your head still and follow the stimulus with your eyes only. They're going to ask you to not move your head, and they're going to ask you to, if they understand the instructions. So like I said, from my experience, I've seen it with a pen with a light on the end, or the officer flashing his or her light and asking the individual to follow the pen or some kind of instrument. Obviously, you might say, well, if I've got a light blinding my eyes, I might not necessarily be able to properly perform this test, and I would agree with that. And some of the clues where an officer might think you failed is a lack of smooth pursuit, a distinct nystagmus and a maximum deviation, and an angle of onset prior to 45 degrees. Now that all sounds confusing, I'm sure, to some. So if we go to the next slide, we're going to provide a little bit more information regarding a nystagmus. Next slide, please. Okay, so I'll just read right from here. Nystagmus is an involuntary jerking or bouncing of the eyeball that occurs when there is a disturbance of the vestibular inner ear system or the ocular motor control of the eye. HGN refers to a lateral horizontal jerking when the eye gazes to the side. In the impaired driving context, alcohol consumption or consumption of certain or other central nervous system depressants, inhalants, or phenycetidine hinders the ability of the brain to correctly control eye muscles, therefore causing the jerk or bounce associated with HGN. As the degree of impairment becomes greater, the jerking or bouncing, i.e. the nystagmus, becomes more pronounced. This is assessed in the horizontal gaze nystagmus test. So what are all those big words mean? Basically, it means that your eye is jumping around or jerking around involuntarily when you're, supposed to be following this pen or whatever instrument the officer is asking you to follow. Now, that's a bunch of science. I don't necessarily know if that 100% should, prove that somebody is impaired. So that is why there are multiple tests, that field sobriety test that an individual has to undergo. And you will also see in coming up slides that sometimes these tests aren't always reliable. I think when you look at some of these cases, whether you're going to a trial or not, it's the totality of the circumstances with all these tests. Is it one failed test? Is it two failed tests? Is it all failed tests? So keep in mind, the information presented here, it's always about the totality of the circumstances, not just, well, you failed one individual test, so now you're going to be convicted of driving while impaired or intoxicated. Next slide, please. Okay. Just as we mentioned, there are problems with the horizontal gaze nystagmus test. Results are only 78% reliable under optimum conditions. The tests are never administered under optimum conditions, and we'll get back to that in a second. Flashing lights from police cars or lights from passing traffic can impact the results. Obviously, individuals have eye problems. They might have seizure medications that can create false positives. And despite this, is probably the most reliable of all the FSTs, but jurors don't understand the test and have the tendency to disregard its validity. So kind of like I was saying earlier, I read that whole slide about what nystagmus is, and I almost confused myself with all those scientific words and whatnot. So, I think it's a very inexact science, and it goes back to our totality of the circumstances, what I stated earlier. When you talk about optimum conditions, what are optimum conditions? Usually it's dry outside, you're on a flat surface, there's no other stimulants around. However, like it says here, if you're getting pulled over, usually there's police lights flashing or passing traffic. And, the other thing is people are nervous under these conditions. People are going to, maybe not follow the test as easily as they can, because I think in any situation when an individual is pulled over by law enforcement, they're not 100% comfortable, regardless if they've had any alcohol or not. I mean, I'm sure anybody who's been pulled over, that they could have been doing absolutely nothing wrong, at least in their mind. Still, sometimes contact with law enforcement is nerve-wracking, and that's not necessarily accounted for when these field sobriety tests are performed. So let's move on to the next slide, though. Okay. Another field sobriety test is the walk and turn. And in these cases, and I should say, going back to the nystagmus too, is the officers have to give clear instructions as to what kind of test they want you to perform. And I think if an individual is not clear on those tests, it has to be known to the officer. Now, an officer might get a little frustrated that you are asking certain questions. They might think, well, I just told you what to do, comply with my request. But I think it is within your right to request some clarity on the situation. Once again, nerve-wracking, high-stress situation. There's nothing wrong with asking for some clarity on what those instructions are. But for the walk and turn, you'll see the instructions here. The officer will ask you to put your left foot on the line and put your right foot in front of it with your right heel touching your left toe. They'll ask you to keep your hands to the side. They'll ask you, they'll tell you, don't start until I tell you. Once again, they'll ask you, do you understand the directions? I think that's a good time. If you don't understand the directions, seems pretty straightforward, but if you don't, nothing wrong with asking for clarity. And then once you have your feet aligned like that, they'll tell you to begin. They'll take 9 heel-to-toe steps on the line, turn around, keeping one foot on the line, and return 9 heel-to-toe steps. On the 9th step, keep the front foot on the line and turn by taking several small steps with the other foot. They'll tell you while walking to watch your feet at all times, keep your arms at the side, and count the steps. Once you begin, do not stop until the test is complete. Once again, do you understand the instructions? So, it seems like a lot. And, I'm going to be honest with you. A lot of people are clumsy. I'm clumsy myself. I don't know if I could do that in a straight line without even having zero alcohol in me. So once again, these tests aren't necessarily scientifically proven. They're not, 100% reliable, but those are the tests that are put in place. So I think it's imperative that you try to follow them as best as possible. And some of the clues we have is if an individual fails the test is they start too soon, they can't keep their balance, or when they're walking, they miss their heel to the toe, they step off a line. You're supposed to keep your arms down at the side, so if you put your arms out, to see your wingspan or kind of balance yourself with your arms spread out, they're going to say that you failed the test. Another one I don't really like is the wrong number of steps. I mean, what's the big difference if you take 8 steps versus 9 or 10 versus 9? So, but those are all key things to point out. And certainly when you're challenging these, you challenge everything. If the officers have to follow a certain set of rules and procedures, then they better be on top of their game when doing so. And I think it's imperative as attorneys to analyze each and every test and make sure that those law enforcement officers are following those procedures. Because just as attorneys, if we screw up on something procedurally, then that could be a detriment to our case. Same thing with law enforcement. If they don't follow the proper procedures, then it could be a detriment to their case. Next slide, please. Okay. So I was going to get into this, but I'm glad it's kind of brought up here. What are some problems with the walk and turn test? There is no, perfect scientific method, and I think we kind of talked about that. And going back with just as like with the Nystagmus test, when you got blinding lights shining in your face, the walk and turn, you want to be on a clean, dry, and flat surface. Now, it's never going to be 70 degrees sunny with no humidity and no wind. Especially living in New York, you're going to get rainy conditions, you're going to get snowy conditions, you're going to get cold conditions. So I think it's certainly something to bring up. Say it's like pouring rain out and your client has to perform these tests. I think that you have an argument there that maybe he or she slipped, maybe he or she doesn't have good balance, doesn't have coordination going back. I'm clumsy, and that doesn't mean I'm driving in a vehicle while impaired. So some of those things to keep about when you're looking at these tests. Even here, it says people who are overweight, they might have difficulty doing a walking turn or standing on one leg by themselves. Something else to think about is when the officer asks you to walk a line, sometimes there is no line specifically physically there for a person to follow. So now you're walking on an imaginary straight line that is not your imaginary straight line, it's the officer's imaginary straight line. So you might have an idea that you're walking a straight line in your own mind, but an officer might think, well, nope, the line is this 2 inches to the right, 2 inches to the left, and that could cause them to fail you. But it's important to remember with any of these tests, and I keep harping on it, is they're never performed under optimal conditions, and something to make sure that you challenge when facing a situation like this. Next slide, please. Okay. Another test is the one-leg stand. Basically, speaks for itself. Stand with your heels together, your arms at your side. Do not begin until I tell you to do so. Once again, they'll ask you, do you understand the instruction? Pretty standard instruction, pretty straightforward, but certainly ask if you need to. Then the officer will tell you they want you to raise one leg, either leg, approximately 6 inches off the ground with your foot pointed out. And they'll ask you to keep both legs straight and keep your eyes on the elevated foot. And then when holding that position, you count out loud 1, 1001, 1, 1002, 1, 1003, and so forth until you're told to stop. If you understand the instructions, you may begin the test. So once again, pretty straightforward, but their clues for how you're quote unquote fail is if you sway, you do use your arms to balance, maybe you hop on the foot or you put the other foot down. So that is another standard field sobriety test, the one leg stand. Next slide, please. Okay. Once again, problems with the one leg stand. As with the walk and turn test, it's designed for a clean, flat, dry environment. It is only 65% reliable. Those who are overweight, have back, leg, inner ear issues, have almost zero chance of passing. It's an open, and this third point raises to my point. Open-ended test intending to raise anxiety of the driver, rather than say counting to 10 is say count until I stop. These are situations where a person's going to feel anxious, going to feel a little bit of fear, and quite frankly, maybe if they have had alcohol in their system, that's going to heighten their level of anxiety. So those are all important factors to keep when you're looking at these tests. And you know, this is also too, once again, based on a officer's observation. Clearly, if that officer pulls you over, detects alcohol, they're not looking to let you go. They're looking to jam you up and charge you with driving while intoxicated or some type of alcohol, drug-related vehicle violation. So keep in mind that these are from an officer's point of view of how you're performing as well as you think you perform. You know, I always get clients that call me up and say, well, I got arrested for this, and I performed the field sobriety test, and I passed that, but the officer said I failed. And we'll get into this in a little bit with the new discovery laws that are certainly going to help out with, the requirement of body camera footage. But something to keep in mind, I'm sure, 4 out of every 5 or 9 out of every 10 clients that get charged with DWI and they say they failed the field sobriety test are going to come back and say, well, I didn't fail, and the officer is going to say different. So those are some of the things to keep in mind down the road when you challenge those actual tests. Next slide, please. Okay, so are these standard field sobriety tests reliable? They are, in a sense, and there are some data here to back it up, but also I think you have to keep in mind as counselors that just because an individual fails a field sobriety test, that doesn't necessarily mean that it's case closed, you're done, you're going to be convicted. I think, once again, it's challenging these battery of tests. It's looking at every procedure that law enforcement used. Certainly, it's not going to help your client's cause if they did legitimately fail these tests, but it's not 100% accurate. You can't convict someone solely because they failed some field sobriety tests. So certainly keep those in mind, and anybody who's a prosecutor might disagree, but keep those in mind when you are challenging your client's DWI or DWAI arrests or charges. Next slide, please. Okay. And, I kind of touched on this a little bit, goes to my point about discovery. So basically, once the discovery laws changed in New York a couple years ago, every law enforcement agency operating in New York must have their officers wear a body-worn camera. And everything needs to be turned over to the prosecution under automatic discovery. And just as it states there, the footage will give you the ability to dispute the officer's observations both before and during the field sobriety test. What do you mean before and during? Essentially, you get pulled over, they're approaching your vehicle, they're asking you those initial questions as to, have you been drinking, or maybe even their observation. They might, on their, I hope an officer wouldn't do this, but on their arrest report, they might say the person had slurred speech, bloodshot eyes, their hair was disheveled, and they were fidgety. And you get a body cam footage, and you see the officer walking up, and that person's sitting there. Maybe they got 2 hands on the wheel. Their hair is nice and kept. They're talking clearly. They're not slurring or anything like that. So that could put a dent in the officer's observations. You could challenge that because now you have body camera footage stating otherwise. Obviously, that could go the other way. The body camera footage could justify the officer's observations, their reasons for pulling you over, the reasons for asking you to perform the field sobriety test. So those are certainly some things to keep in mind. But now with discovery, It's an open book, and rightfully so. I think we're beyond the time of just relying on anything a law enforcement officer says. So now with the discovery laws, you need to be provided with all reports, body cam footage, any other video recordings, and audio recordings of the stop. And as it states here, you know, when you get pulled over, it's not usually just one person. An officer at least usually has a partner or a backup that is there. So it's not just the arresting officer. It's not just the officer performing the field sobriety test. It's any officer that was present on the scene, interacted with the driver, and you know, that conversed with them, or maybe they were just observing their partner. That individual's body camera footage does need to be provided to you. Next slide, please. Okay. Taylor, you want to take over this part quick?
Yeah, I'm going to call out the first course code that you need to write down. The first code's going to be 867530. Again, the first course code is going to be 867530. And I'm going to move on to the next slide.
Okay, thanks, Taylor. So another part of the field sobriety test on the road, if you will, is a portable alcohol screening device. And I think it's important to note that this is different, excuse me, than your breathalyzer that you might give at the police barracks, at the police station, at a sheriff's station. It's not the actual test that you see where it says, oh, the person registered a BAC of 0.12, 0.13, things of that nature. It's a portable alcohol screening device, in that once the field sobriety tests are complete, an officer is going to ask you to submit to the alcohol screen to determine whether you've been drinking that evening. As it states here, it's an integral piece of probable cause, and while it may not be required, a failure at this level validates everything that occurred before. And it has been held that the results of this screening are inadmissible at trial. And what that means, though, the pre-breath test, it's not going to give you necessarily a reading. It's not going to give you a 0.08, a 0.12, a 0.18. It's going to detect whether there is alcohol in your system. And kind of like it says there, it essentially just justifies the failure, or if the officer fails you on those field sobriety tests, that, okay, they failed this field sobriety test, now we have proof that there is alcohol in their system. So once again, they can never use that solely against you or to prove your intoxication. And in fact, you will see under the VTL, refusable to take the PBT is just a ticket. It's not, it's different from a valid chemical refusal down the road that could have serious implications on your driver's license. It's simply used to justify the failed field sobriety test. And when I say justified, that is for the law enforcement, not necessarily for your client. And you'll see there, it's generally not accepted in the relevant scientific community, and it can't necessarily be the sole reason why you are convicted of driving while ability impaired or driving while intoxicated. However, as noted here, the First Department appellate term had held the roadside alcohol sensor should be admissible at trial, as it is on the list of devices approved for testing by the Department of Health. Once again, okay, even if you can get that in at trial, it doesn't mean you are definitively should be convicted of driving under the influence or driving while intoxicated. Next slide, please. Okay, so now you've gone through the field sobriety test. The officers are going to determine that your client has failed, and now they have probable cause to believe that the driver has committed an alcohol-related offense, and they're going to put the driver under arrest. And that starts the clock for the 2-hour complied consent clock. And just to note too, if a driver is suspected of violating any section of the Vehicle and Traffic Law 1192 and involved a fatal or serious physical injury or crash, a court order can be applied for and secured to compel a blood draw. So what that means is maybe someone is involved in a fatal accident or like it says, a serious physical injury crash, and they might not have the ability to A, blow into a breathalyzer, or B, speak their consent one way or the other to give that breath sample. In that case, a blood draw can be compelled. And down the road, sometimes if law enforcement, for whatever reason, if a person doesn't want to blow, they might ask if they have consent to draw blood, and if they don't have consent, if the person refuses then that also could be considered a valid refusal. Something to note here, there is no requirement that the blood or breath sample be taken within 2 hours of the arrest, and if a sample is taken 2 hours after, there is no basis for suppression of that evidence. At the end of 2 hours, the driver implied consent ends, but nothing stops the police from requesting a sample after 2 hours, to which the driver could voluntarily give consent, or they could invoke their Sixth Amendment right to counsel. And in that case, the request cannot be made without counsel being present to advise the driver. So I'll give you an example. This is not now at the roadway. Say this is back at the police station. This is back at the trooper barracks. This is when they're going to ask you to give the breath sample that is going to be used against that person in an actual proceeding, the actual scientific reading. And, I'll give you an example of a refusal warning. So if someone's arrested, the operator is warned as follows. Refusal to submit to a chemical test, or any portion thereof, will result in immediate suspension and subsequent revocation of your license or operating privilege, whether or not you are found guilty of the charge for which you are arrested. Your refusal to submit to a chemical test, or any portion thereof, can be introduced into evidence against you at any trial, proceeding, or hearing resulting from this arrest. And then after receiving the warning, the operator is then asked to submit to a chemical test. Now, just to kind of give you a little aside here, is that an individual, if they refuse to submit to the chemical test at that point, we talked about the consciousness of guilt instruction, meaning the prosecution is going to have a 0 BAC because the individual refused. However, they can get the consciousness of guilt instruction at trial. And further, a refusal is going to initiate a separate proceeding with the DMV in connection with the person's license. So now if you refuse, you have your charge in your local city, village court in connection with driving while intoxicated. And then you're going to have a separate proceeding, administrative hearing with the New York State DMV regarding your refusal. And the tricky part about that is, or the interesting part is, an individual, say they are charged with driving while intoxicated, it goes all the way to trial, and they're found not guilty. And so there's no consequences in connection with their license. However, you can still have a DMV refusal hearing, and the administrative judge can rule that the person did not have a valid reason for refusal, and then your license is going to get revoked for a year. So there are situations where somebody is cleared of any driving while intoxicated charges. However, they do have their license revoked for a year simply because they refuse to submit to the chemical test. It's not the norm, but it is a situation where I've seen something like that. And the last part of this slide here is, always pay attention to the warnings that were given to your client. Should the warnings misstate the consequences of refusing or be legally inaccurate in any way, the results of a chemical test could be suppressed even if a defendant consented to take the test outside of the statutory 2-hour implied consent clock. Meaning, it's just like anything else, and I mentioned this earlier. If law enforcement doesn't follow the proper procedure, fails to give the correct warnings, even if it's no different than a custodial interview where your client basically admits to everything, but if the officer doesn't give the appropriate warnings, then that confession is thrown out. It's no different here. If the officer doesn't give the proper warnings, doesn't state the correct consequences, and your client still does in fact proceed with the chemical test, maybe it's not a good result, but if the officer didn't follow the procedures, you can get that evidence suppressed. Next slide. All right. The breathalyzer and the right to counsel. A lot of times people say, well, I want my lawyer. I got to speak to a lawyer. And that's true. You do have a right to speak to counsel. after you've been arrested for a DWI, but you haven't been arraigned, and that is in connection with the submitted chemical test. The defendant requests an opportunity to speak to an attorney, and there's no danger of delay in the administration of the chemical test. As it states there, an officer must be an active participant by assisting the defendant in contacting a lawyer and cannot just sit by idle. However, it's been my experience that you can't just say, well, I want to talk to a lawyer. I mean, maybe the officer reaches out if the person doesn't have a particular person in mind. Or they say, well, my lawyer's Derrick Hogan. You call him and you call me over and over. Maybe I'm in court. Maybe I'm not around. Maybe I don't have my phone. It's not like you have an absolute right to talk. I think if the officer makes reasonable efforts to contact the person's attorney, and a court's going to rule that it's reasonable and sufficient. If the person doesn't have an attorney, maybe they contact the public defender's office. Maybe they could contact an attorney they know, the officer knows, that might be able to answer that question. But, it's certainly a case-by-case thing. But simply because a person requests a lawyer at that time regarding the chemical test doesn't mean the test is always going to get thrown out just because the lawyer wasn't contacted, or they did not make contact with the lawyer. Next slide. Okay. All this is a bunch of scientific information here to say that, these are the reasons why we think somebody's, alcohol level is above a certain part in your system. And I think the big thing you have to think about these things is DWIs are also science-based too. But once again, and I know I'm kind of harping on it, I think the best way to beat these kind of cases is, the prosecution's going to rely on some science. They're going to rely on some type of breath sample, but it's procedures. It's procedure. And that goes with any kind of legal matter, but specifically in these DWI matters. Did the officers follow procedure? Did they follow the law? Did they do it correctly? And so that is a big thing to think about when looking at these types of cases. Next question, or next slide, please. All right, so once again, in discovery, with the new discovery laws, you are to be provided with any and all information in connection with these breath tests, these chemical tests. That could be, is the actual machine functioning? Is it properly functioned? Is it properly tested? When was the last time it was tested? Who did the testing? Is that person certified to conduct those tests? Those are all things. Is it calibrated correctly? Those are all things that you are entitled to, and prosecutors are going to have to provide that to you. And I think that's where you have to look at your cases. You have to go through with a fine-tooth comb and determine whether or not proper procedures were followed, or is this instrument valid? I mean, if you get something back, I would hope not, from law enforcement that says the last time this was calibrated was 2015, you certainly have a better chance. Or when was the last time the operator was certified? Well, the operator was certified back in 2010. I don't think that's going to fly. But also, if the person is certified, say, in 22, 21, 20, then you're going to have a less of an argument. Basically, you can always attack the breath test. Just because some machine reads it one way, you can always attack the test. And make sure to look at the different readings, the different certifications, things of that nature. Next slide. All right, and I believe this is our last slide, and I know we said we would be open to some questions too. Basically, once the person is charged, you're going to go through the procedures. You're going to file your motions. You're going to try to get things dismissed. But I can't be more, clear on that. You got to follow you got to see what procedures were followed. Officers are held to a certain standard. They're going to arrest somebody for this. They need to be following the rules. And a couple things the person could be charged with. If their BAC is below 0.08, and I want to say it's above 0.05, they can be charged with driving while ability impaired by alcohol, which is just a violation. If it's 0.08 or more, they'll be charged with what we would say misdemeanor DWI, driving while intoxicated, or if it's above 0.18, 18 and above, you're going to be charged with aggravated DWI. And I think it's important to note, because I get this question all the time, is, you know, what makes it a felony? Well, your BAC is never going to be a reason why an individual is charged with a felony DWI. The felony DWI charge has to do with the fact that the person has 2 vehicle and traffic 1192 convictions within 10 years. So, you know, as silly as it sounds, there's really no difference between a 0.18 and a 0.28, 0.38. Obviously, if it's 0.38, you might want to check to see if the person has a pulse, but there is no difference, and that's not going to make it a felony. A felony is going to make it, it's going to be made a felony depending on how many convictions the person has within the past 10 years. Or I should say not how many. If they have 1 DWI conviction in the past 10 years, the next one's going to be a felony, regardless of what their BAC is. So with that, I hope I've enlightened some of you and provided some valuable information. And with that, I'll turn it over to Taylor if there's anything else we need to discuss.
If anybody has any questions to ask Derrick, please send it in the chat, and we will go over questions after the next course code. Course code number 2 is going to be 108627. Again, the second course code is going to be 108627. And Derrick, we have 1 question so far, so I'm just going to send that over to you.
Okay. All right, so would you advise drivers to submit to or refuse the handheld breath test? I mean, you know, I think it can go either way, but the way I look at it as is, that's not the worst thing in the world if you refuse or if you take it, because like I said, what matters is the chemical test at the sheriff's station, at the trooper barracks and whatnot. So you perform the field sobriety test, and if you do refuse that roadside test, they're just going to add that to vehicle and traffic ticket. So say you get pulled over for speeding, you're going to get a speeding ticket, you're going to get a refusal to take that test. Because say you do refuse, but then you go to the station and you blow, that's kind of null and void at that point. So, and it also just gives them more probable cause. So I don't think there's anything wrong with refusing it. Obviously, you take it if you're confident that you're not impaired, but also I don't see the major negative consequences of refusing it beside getting a vehicle and traffic ticket, because you could go to the station and you can blow on the actual chemical test. I think that's where you're going to get more, you're in trouble, or you're going to have more of an uphill battle, is if you refuse the chemical test at the station. Whether or not you take the roadside test, I don't think it has that many consequences one way or the other, but with the exception that you'll just get another vehicle and traffic ticket.
Thank you for answering that, Derrick. That seems like the only question that we had in the chat. So thank you everyone again for joining today's presentation, and thank you, Derrick, for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you so much for attending.
Thank you, everyone.